Democratic Alliance has confirmed it has received the ANC's cadre deployment documents in compliance with the Constitutional Court order. The Apex Court dismissed the ANC's petition to appeal last week. The governing party had approached the court hoping to overturn a decision of the Supreme Court of Appeal that it hands over the documents to its main opposition. The opposition has now confirmed that it has received the tranche of documents it first requested over 3 years ago. I speak now to legal expert Modidima Mannya, joining us for more on this story. Good to have you, and thank you very much for coming on this evening. Let's just go a little bit back in terms of this matter. One, you have the Constitution, Section 32, if I'm correct, could be allowing this kind of access, and hence we've created some kind of legislation that allows the public to request certain information which they believe is within their right and certainly is required in assessing those in power, whether they're carrying out their duties as they should. I'm paraphrasing basically what the legal terms are. But at this particular point, you have the Democratic Alliance saying, look, we have a right, as per the Section 50, subsection 1, subsection A of the prior Act, to have this information. One, because we are drafting legislation to be able to monitor cadre deployment and that it is done correctly. But secondly, we need it for oversight purposes to ensure that those who are appointed at state institutions they are doing exactly what they are appointed for, and those processes are not interfered with. Does that limit how they can use this information?
Yes, Tabo, and good evening to your viewers. Maybe let me preface this by saying I would call on all political parties to say to South Africans they have not at any stage tried to influence the appointment of anybody in public administration, and I'm talking about the administration generally, including even lobbying the very ANC to appoint people that they prefer. And I can take you back to 1994, where after the first general elections, KwaZulu-Natal was under the IFP. And let the IFP tell us, how did they identify the first Director General of the province? The Western Cape was under the National Party. They must tell us how they identified the first Director General of that province. So I'm just giving you as an example, and I think the proposition I want to make at the outset is that no political party must come and try and fool South Africans and say, by no means do they get involved in influencing appointments in the public service. Where the DA has got a valid point is the principle that the Constitution requires that the public service and public administration generally must be on a professional basis. There they have got a valid point. But whether they practice that themselves, like all other political parties, is a question that we must debate. With regard to the question that you are asking specifically, I think first one needs to see what is in these documents. But interestingly, I'm not sure whether everybody who would be mentioned in that would even be aware that they were being discussed for deployment purposes. Because firstly, we don't know how the discussions took place, what was the criteria. Bear in mind that the actual appointments are done in government, and at least at face value, they follow the procedure which is required by national legislation. So I think this is going to be very, very, very intriguing and interesting. But let me also conclude by saying the relief sought by the DA is for the declaration of the ANC cadre deployment policy to be inconsistent with the Constitution. I am not sure why, if that is all what they require, they now want all these menace to flash around, but I've seen their statement today, and I think it's part of the electioneering campaign. Yeah. And I can tell you now, Thabo, any party that is in power is capable of being corrupt. It's not just the ANC. Any party that is in power. Corruption has got nothing to do with a particular political party. It's got to do with power. So anybody who's in power is capable of being corrupt.
So the DA says now we are studying these records to ensure that the ANC is in full compliance with the Constitutional Court ruling that they've given us full record Now, we've got a statement from the ANC earlier on already indicating to say, well, we've already said long ago in 2021 or even earlier than that when we were at the State Capture Commission that we don't have the full records. In fact, as far as we are sitting, we've got a record from 2018 until 2021. From 2012 up until 2017, we are not sure where that record is. I think whether it exists or whether it is lost. Now, part of the Act says that if all reasonable steps have been taken to find a record requested and there are reasonable grounds for believing that the records in possession of this private body cannot be found or do not exist, the party just needs to write an affidavit and line out what they've done to the requester and say, well, look, we can't find these documents. Does that make the victory a little bit hollow for the Democratic Alliance?
Well, I'm just thinking, Thabo, let's say I was in the deployment committee and I had an iPhone then in 2013, which I sent SMSs through, and then, of course, it became obsolete. I no longer use it. I don't even know where it is. And the order says I must produce those SMSs or WhatsApp. It's impossible to do so. So you become in contempt of court when you are deliberate, when you have no justification not to comply. In many instances, records are kept at least for 5 years. So as you can see, this dates back to 2013, which is well over the 5-year period. And the chances are that some of the records do not actually exist. But I'm also asking myself the question, let's assume the records of 2013 exist. So what? What is going to be the value of what happened in 2013 now in 2024? Let's say I was the subject of a deployment by the ANC in 2013, and I have served a 5-year term, say, as a Director General. I've left now, I'm in private practice. What is going to be the significance of you producing that information? So part of it may just be even irrelevant to what the DA itself says it seeks to achieve. If this is meant for the purposes of the new legislation that is required or is being undertaken, there are very clear principles that you can invoke to do that. I know that the government, for instance, is busy. There's a bill, I think, before Parliament, which seeks to deal with the appointment of people in state-owned enterprises. There's already legislation which deals with appointments in the public service, in municipalities. You know that there's been suggestions for an amendment. In fact, there has been an amendment to try and even bar some of the senior union officials from occupying certain positions in municipalities. So I think that in terms of information specific, to the extent that that information no longer exists, there's not much the court can do to help the DA.
Yeah. Promotion to Access to Information Act also, as you've already mentioned, says that mandatory protection of the privacy of third parties who are natural persons is also a ground for denial of particular information. Could it be that the documents that the DA has in its possession actually has no names? Because the requester can request, but the private body can give you the documents without those names, a redacted version, so to speak, to protect them as per the requirement of Section 63.
Yes, I don't know how the ANC dealt with that information. Naturally, there should be names of people. I don't think that there could have been a meeting where I'm called an X and you are called a Y as if we are chromosomes. But I suppose that there would be names. If the ANC has not redacted, the ball is in the court of the DA because it's the one that will be publishing. As I say, it's very possible that there are a number of people who didn't even know that they were being discussed in the deployment committee of the ANC. And some of them will take the DA to task to the extent that it will publish that without any verification. What I don't know is what will the DA do to verify whether I have been party to a deployment. It's one thing to have a fight between the DA and the ANC about deployment, but I have got rights as a person, and I have the right to protect my rights. So it may as well be that the way the DA will handle the information may expose it to trouble.
Yeah, indeed. And I suppose, is there protection for the ANC, in a sense, from the DA using that information for their political advantage? The ANC saying in their statement that would be spitting on the very constitution that you're saying you want to uphold.
Well, look, I mean, I think South Africans are smart enough to understand this is election season. You know, we'll have the ANC throwing mud at the EFF, at the UDM, at the ATM. And so this is election season. But I think what any one of the parties must bear in mind is that the Constitution also protects the rights of individuals. And in the same way that the DA has been able to get these documents through a court order, nothing prevents those that are affected from interdicting it, from making it public. I saw the DA statement says, look, we are studying this, we are going to make the information public, and I hope that they know very well what they are getting themselves in.
So, circling back to where you started, what is preventing the ANC from making a similar application to all the parties?
Well, that's why I said I'm not sure how the ANC dealt with the information. Remember, we haven't seen the information tab. It's possible that they also invoked those protections and redacted some of the information. It is possible that they gave the information not redacted, but if they gave the information which is not redacted, they wouldn't have broken any law. What would probably happen is whoever then uses the information will have to comply with the personal information of those that are affected. Sure. You know, for instance, as I understand, one of the documents or some of the documents are the curriculum vitae of the various people that contained very private information. In as much as they got it through the court order, the order doesn't authorize them to make the information public and use it for any other purpose. So they will still have to comply with the law. And so they might actually, as I say, find themselves having opened up a can of worms and have bees flying all over them.
Some technicalities. The legal expert, Modidima Mannya, appreciate your time.